Hello and welcome to Courts Today by LiveLaw. I am your host Chauhan, here to keep you informed with the latest and most important updates from the legal world. First, we will cover the top headlines, followed by an in-depth look at each major update. The Supreme Court has directed Uttar Pradesh government to pay 25 lakhs interim compensation for illegal demolition. The Supreme Court has held that holder of LMV driving license does not need separate authorization to drive transport vehicle weighing less than 7,500 kg. The Delhi High Court Bar Association has decided against reservation for women lawyers in the bar elections. The Calcutta High Court has called for state's report on a plea over alleged communal violence. The court was surprised at the leader of opposition appearing as petitioner in the PILs. In the ongoing NCP dispute before the Supreme Court, Ajit Pawar has agreed to publish within 36 hours disclaimers in newspapers regarding the clock symbol. The top court has held that Section 197 of CrPC applies to PMLA and therefore prior sanction is mandatory to prosecute public servants for money laundering offence. And the Delhi High Court has rejected a PIL to allow Chhath Puja celebration at Yamuna after the government flagged river's pollution level. The Supreme Court today came down heavily on the authorities of state of Uttar Pradesh for the illegal demolition of residential houses for a road widening project. The court was hearing a suo motu writ petition registered in the year 2020 based on a complaint filed by Manoj Akash, whose house in district Maharajganj was demolished in the year 2019. The bench of CJI D.Y. Chandrachud, Justices J.B. Pardiwala and Manoj Mishra was informed that 123 other constructions were also demolished and people were just given information through public announcements without any notice. The court expressed serious dissatisfaction with the conduct of the authorities, terming their acts as high-handed. Responding to the state's argument that the petitioner had encroached public land, CJI Chandrachud flagged that no notice was served and no due process was followed. The bench relied on a report of the National Human Rights Commission that at the highest there was an encroachment of 3.70 square meters, but it was not a justification to demolish the entire house. NHRC recommended the grant of interim compensation to the petitioner, registration of FIR on the complaint of the petitioner, and initiation of a departmental action against the officers. But no inquiry was carried out by the authorities to demarcate the encroachments. Also, there was no material to show that the land was acquired before the demolitions were carried out. The court therefore has directed the state to pay punitive compensation of 25 lakhs to the petitioner. This compensation is of an interim nature and would not come in the way of the petitioner adopting other legal proceedings for compensation. The court has also directed the Uttar Pradesh Chief Secretary to conduct an inquiry against all officers and contractors who were responsible for the illegal demolitions and initiate disciplinary actions. Significantly, the judgment has also laid down the steps that the state authorities must follow before removing encroachments for road widening projects. In another judgment delivered today, the Supreme Court has held that anyone with a light motor vehicle license can drive a transport vehicle with an unladen weight under 7,500 kg without needing any additional endorsement. If the gross weight of the vehicle is within 7,500 kg, the driver with an LMV license can drive such a transport vehicle. The 5-judge Constitution bench noted that no empirical data has been brought before it to show that LMV license holders driving transport vehicles are a significant cause of road accidents. The additional eligibility requirement to drive transport vehicles will apply to only those transport vehicles which weigh more than 7,500 kgs. The 5-judge Constitution bench was considering a reference which doubted the decision in Mukund Devangan versus Oriental Insurance Company Limited in 2017. The bench that decided the matter comprised CJI D.Y. Chandrachud, Justices Rishikesh Roy, P.S. Narasimha, Pankaj Mithal and Manoj Mishra. For a detailed reading of this judgment, you can visit livelaw.in. In the matter concerning reservation for women lawyers in Delhi High Court Bar Association, the association has filed a response stating that there can be no reservation in a private association. The Supreme Court is dealing with 3 petitions seeking reservation for women lawyers in Bar Council of Delhi, Delhi High Court Bar Association and all district bar associations. In September, the top court had asked the Delhi High Court Bar Association to consider reserving the post of Vice President for women lawyers in the upcoming elections. The bench further found it disappointing that since the year 1962, there had not been even a single woman president of the bar. Subsequently, the court directed that a meeting of the general body of the association be held to consider the desirability of reserving the post of treasurer for women members. The general body was also at liberty to consider desirability of reserving one more post of office bearers for women members. Pursuant to this order, the association has now filed a response. According to the association, a general body meeting was held on 7th October, wherein in unison they stated that they were not in favor of any reservation in the seats of the executive committee in any form. Association claims that the step of reserving a post for any particular class or category of members shall have consequences which will render the working of the association difficult. This would lead to other classes and categories coming forward and seeking similar relief. With respect to the upcoming elections, the association states that some candidates had announced their candidacy as early as in 2022, right after the last Bar Association elections. Therefore, the petitioner's request for reservations in the current election is not feasible and would actually be unfair to those candidates who have already put in significant effort and contributions towards the association's work. So, it has urged that the petitions be dismissed and the matter be allowed to continue before the Delhi High Court where it is pending. In the next update, the Calcutta High Court today heard a plea alleging instances of communal violence against Hindus and Sikhs in Kolkata's Raja Bazar area, which resulted in the alleged targeting of those belonging to the Hindu and Sikh communities. The plea has been moved by Leader of Opposition and BJP MLA Suvendu Adhikari and was heard by the Division Bench of Chief Justice T.S. Sivangnanam and Justice Hirannamay Bhattacharya. The petitioner submitted that there were huge mobs which had gathered at the Raja Bazar area during the puja celebrations, and members of the particular community were engaged in attacking those belonging to Hindu and Sikh communities and desecrating the puja pandals and temples. It was argued that stones were pelted and bombs were thrown. On a query by the Chief Justice about why these occurrences were not reported in the newspapers, the council claimed that journalists reporting on the issue were being arrested and had their bank accounts frozen. On the other hand, the Advocate General appearing for the state submitted that the entire issue was one between two individuals which had escalated into mob violence due to the use of a sword and firearm by the aggressor. The petitioner's counsel prayed that the plea be transferred to National Investigating Agency due to the use of explosive substances. It was argued that while politicians can file public interest litigations, the court should be cautious with petitions from those frequently critical of the state government as they might seek political advantage. The Chief Justice noted that Leader of the Opposition as the petitioner was unusual, as such cases are typically handled by the party's legal cell or a similar representative. The court has directed the state to file a response on the plea and has kept it for hearing on 19th November. Stay tuned. Nationalist Congress Party Chief Ajit Pawar today assured the Supreme Court that within 36 hours, he will publish a disclaimer in prominent sections of newspapers, including Marathi dailies, stating that the use of clock symbol by the NCP remains a sub judice matter. Senior Advocate Balbir Singh made this undertaking on behalf of Ajit Pawar in response to an oral direction given by the Supreme Court. A bench of Justices Suryakant, Dipankar Datta and Ujjal Bhuya was dealing with an application filed by the Sharad Pawar group seeking to restrain the Ajit Pawar group from using the clock symbol in the upcoming Maharashtra Assembly elections. Through this application, Sharad Pawar sought to direct Ajit Pawar to apply for a new symbol to contest the Vidhan Sabha elections. If you remember that in March and April, ahead of the Lok Sabha elections, the court had directed NCP to include a disclaimer in all the campaign materials that the use of the clock symbol is subject to the result of the litigation. Last month, the court directed Ajit Pawar to file an undertaking to the effect that previous orders will be followed for the state assembly elections as well. Further, the bench orally warned that it would initiate suo motu contempt if its orders were violated. During today's hearing, senior advocate Balbir Singh claimed that the NCP was complying with all conditions imposed by the Supreme Court for the use of the clock symbol. He added that the party has contacted newspapers to publish a fresh undertaking. In another update, the Supreme Court has held that Section 197, Clause 1 of CrPC will apply to cases under Prevention of Money Laundering Act. This section states that prior sanction from the government is required to prosecute public servants and judges for offences alleged while they are discharging public duties. A bench of Justice Abhay Oak and Justice Augustine George Massey dismissed an appeal by the Directorate of Enforcement challenging Telangana High Court's order that had set aside cognizance orders against an IS officer on the ground of lack of any prior sanction. The allegations against the respondent IS officer involved misuse of official position in land allotments, undervaluation of assets, and unauthorized concessions that allegedly benefited private companies and caused loss to government. The companies were linked to former Andhra Pradesh Chief Minister Y.S. Jagan Mohan Reddy. Before the High Court, the officer contended that he acted within official capacity, arguing that prior government sanction was necessary for prosecution. ED argued that PMLA, being a special statute with overriding provisions, does not require such sanction, as the PMLA is a complete code providing procedure for everything. But the High Court in January 2019 had set aside the cognizance orders and held that lack of required prior sanction rendered the cognizance orders unsustainable. This order of the High Court has now been upheld by the Supreme Court. And lastly, the Delhi High Court today dismissed a PIL which sought to allow the public to perform festival of Chhath Puja at Gita Colony Ghats on the Yamuna river bed in the national capital. A division bench comprising Chief Justice Manmohan and Justice Tushar Rao Gadela rejected the PIL moved by Purvanchal Navnirman Sansthan, observing that performance of Chhath Puja on the Yamuna river bed will be harmful for the devotees, keeping in view its pollution level. Delhi Government's counsel Santosh Kumar Tripathi told the court that the Yamuna river is highly polluted at this juncture, and if the devotees are allowed to perform Chhath Puja on the river bed, they are likely to fall sick. He also told the court that the Delhi government has earmarked 1,000 spots to perform the Chhath Puja in the national capital, and sufficient arrangements are made for the same. The counsel appearing for the petitioner organization said that the blanket ban on performance of Chhath Puja must be lifted. As he said that Yamuna riverbed can be cleaned, the Chief Justice remarked that it is a challenging exercise and not something that can be done overnight. The Chief Justice suggested that if one wants to be involved in the cleaning up process, they should contribute to it. For more details on the cases mentioned here, please visit our website at www.livelaw.in. Stay ahead with quick legal updates only on LiveLaw. Do not forget to like, share and subscribe to our channel. You can support us by donating through the thanks button at the bottom of our videos or by becoming a member for just 89 rupees per month.